which we are very pleased to be running in conjunction with Cliffe, Dekker, Hofmeyr Incorporated, and which we have called COVID-19, the Employer's Survival Guide for SAEFA members. I'm pleased to say that we've got well over 200 employers participating in today's event, which is incredibly encouraging for us. And we anticipate that this will be the first of a number of webinars that we plan to run to keep members informed about developments and matters concerning our industry. While the current crisis is undoubtedly the most serious that we and the rest of the world have had to face in recent memory, we're also encouraged by the firm and positive steps that our presidents and our governments have taken to try and limit the inevitable suffering and damage that is resulting from this pandemic. At the same time, the extremely tight deadlines, as well as the complexity of rules and regulations that have to be dealt with, have resulted in mixed and sometimes contradictory messages coming to us from the various authorities, and we at SAEFA are well aware of the huge pressures that our member companies have had to face in making critical decisions about their organization's futures, sometimes without all the necessary information, and also in a matter of a few hours in many occasions. Since the nationwide lockdown was announced by our president on Monday, the 23rd of March, we in the SAEFA office have responded to literally hundreds of phone calls, emails, and other messages relating to this matter, and we've been doing our best to try and answer all of our members' questions, often, as I've said, in the face of different and sometimes contradictory pieces of information being available, as well as regrettably sometimes so-called fake news. During this time, we've been impressed by the concern that most of our members have shown, not only for the survival of their own businesses, but of course in how to act in the best interests of their employees as well. We can assure all of you that we will continue to keep you informed of developments as they are made available to us, and to respond to your queries as best we can. We also have the matter of our industry's wage negotiations on the cards for 2020, and that's something that I'll make some comments on towards the end of the webinar. I'd like to finish this introduction just by thanking everybody who's been involved in setting up this webinar, to our staff for the long hours and untiring efforts that they've put in guiding members with all of their queries. And I'd like to thank Fiona Lepan, Director in the Employment Practice at Cliffe, Dekker, Hofmeyr, one of the speakers today, for reaching out to us with this initiative, and to the IT and communications team at Cliffe, Dekker, Hofmeyr for organising this webinar platform for today. Without any further ado, I'd like to hand over to Adil Patel, Director at Cliffe, Dekker, Hofmeyr and National Head of Employment Practice. Over to you, Adil. Thank you.
Hello, good afternoon, and welcome to what we hope will be many more engagements between our firm and the respective partners. Certainly, we live in torrid times and in uncertain times. The legislation and rules change on a daily basis. What was appropriate yesterday may not be may not be appropriate today. We've just received some sort of information that applications to the TERS is going to be amended and further rules are going to come out. We've had discussions whether there is a National Disaster Benefit Fund. We've had the press report that employees are unable to be forced to take annual leave, while the Minister of Labour's written statement says otherwise. Certainly, the way that we are working from home, the way that we are using technology to undertake business as usual are going to be lessons for the future. Organizations, when we reach some sort of normality, whatever that means, will have to determine what lessons have they learned through their experiences during these lockdowns. I am now going to hand over to talk about how do you as an employer survive during this lockdown period. To my colleague and somebody that needs no introduction, Fiona Lepan, who you would have dealt with through her dealings with the organization. Thank you, Fiona.
Thank you very much indeed. And it really is, to echo Adil's words from earlier, a privilege to be able to address you this afternoon. And the particular topic that I wish to deal with is the occupational health and safety component of this particular problem. In that regard, I'm going to be dealing with the Compensation for Occupational Injuries and Diseases Act, to which I shall refer as COIDA, and of course the Occupational Health and Safety Act, as you know it, OSH. I'll also be taking you to aspects of the particular hazardous biological agents regulations under the OSH Act, to hopefully give you some clarity as to how the Compensation Commissioner is dealing with this pandemic. Very importantly, before the 20th of March this year, Schedule 3 of the OSH Act, of COIDA, does not make provision for COVID-19 as a compensatable disease. On the 20th of March, our Commissioner, our Compensation Commissioner, signed off a very important notice where he spoke to the issue of occupationally acquired COVID-19. Having done that, it still does not amend Schedule 3 to COIDA. However, it's making reference and it's making an opportunity for claims to come through if this disease has been occupationally acquired. And what does that mean? The mere fact that a person's contracted COVID-19 is not sufficient to mount a claim on the fund. What this means is we go back to basics. We go back to COIDA and we look at the definition of accident. You might say, Fiona, what on earth does this have to do with COVID-19? Don't forget the definition of an accident in COIDA includes illness or a disease or such event. So when I speak about the Act covering a particular illness, then I'm requiring, or I must apply a particular test. First of all, was this illness acquired as a result of the employment? And two, whether it was in course and scope of employment. Did it arise from employment, and did it arise in course and scope? Now, those are two quite separate and distinct factors. So when I speak about arising out of employment, I'm talking to the broad causal connection to the employment relationship. And when I speak to course and scope of employment, it goes to the performance by the employee of their contractual obligations that they are required, obviously, to perform for the employer. And importantly, what our COIDA does, and particularly the notice issued on the 20th of March, is it sets out a category of risk. So it's looking at occupationally acquired COVID-19 in the very high risk bracket, which includes your doctors, your nurses, who have direct contact with a patient who is suffering from COVID. And in particular, all the intubation procedures, as you would expect to see happen in an ICU ward. They have direct contact with a patient, and therefore the risk is in the extreme category. Further in the category, we talk about high risk, and that's talking again to doctors and to nurses and healthcare workers more generally, who are attending to patients in the ward and doing the necessary dispensing medicine and issues of that nature. It also talks to medical transport workers in a high exposure risk bracket, as well as mortuary workers. From there it goes to your medium exposure risk occupations. That's equally important because it's talking to persons who could come into contact with persons with COVID, but they might not know the person either carries it has it or is it even exhibiting any symptoms. And the examples given in that situation include your high volume retail setting, persons in, for example, dealing with the general public, labour centres or consulting rooms or other points of entry. And then the very low risk category, which encompasses those persons who would not ordinarily be coming into contact with members of the public. And it's against the bracket of these particular categories that the Compensation Commissioner is going to have to decide whether or not the acquisition of COVID actually points to a compensatable disease and whether they should receive compensation from the fund. So what's important with regard to Schedule 3, if COVID was to appear there, there's a presumption that it was acquired in course and scope. As I said earlier, COVID is not on Schedule 3 to COIDA, which means that presumption does not apply. And what does that mean for employees? They have to demonstrate to the Compensation Commissioner that this is an occupationally acquired illness. And that's why there's a very comprehensive form that's been set out by the Compensation Commissioner, which every employee would have to fill in if a claim is going to go in against the fund, and it's called the COVID-19 Exposure and Medical Questionnaire. And it's interesting, they want to check, have you been travelling to a risk area and that was not in course and scope? Have you been in known contact with someone who has COVID? So when you look at the questions on this questionnaire, it's very much a situation where the Commissioner is going to assess, do I admit this claim or don't I? There was a view at one stage that only those persons in your high risk or very high risk categories should in fact receive compensation. I disagree with that, but having said that, employees must also remember that they have a responsibility in this situation. If they break that causal connection that I spoke about at the beginning, then it tells them, the Compensation Commissioner, that they might have put themselves out of the jurisdiction for a claim. Let me give you an example. I have employees in a particular factory setting. We're producing tin cans, we're an essential service. The employees walked off the line and refused to work unless we paid danger pay. Now, they actually left the work site for the better part of 2 days. Now, that's a foolish thing for an employee to do, because if you break that particular chain, you might find yourself having been exposed to this illness in a different way, and it will exclude your claim under COIDA. So we use that as one of the reasons for saying, guys, get back to work, because you might be prejudicing yourself in a very different way. Importantly, employers would want employees to be able to claim on the fund if it's an occupationally acquired situation. Why? Because remember the provision in COIDA under section 35 that says that if the employee has a valid claim and is paid out under the fund, the employer is shielded from any civil claims for damages. We call that the law of delict, and in particular, the sort of claim that's envisaged in those circumstances is a negligence claim. And this is equally of value and something for employers to take account of. Why? Because if the employer is not playing the part of ensuring there's PPE, ensuring that it's taken all the necessary steps to safeguard the safety of its workers who have to work during this period, what it doesn't want to do is land up in a situation where it's liable for any aspect of this compensation. It shouldn't do if section 35 applies, but we should be just careful on that point. When we move into a discussion on the OSH Act, I go again to the point about reciprocal obligations. Yes, there are some very useful aspects, both in the Act itself, and you'll be very well aware of the general duties of both employers and employees. But on the 17th of March, the Department of Employment and Labour made an appeal, they called it an appeal, to employers to please comply with the hazardous biological agent regulations under the OSH Act. Now, this has to some extent caused some confusion because the, if I may call it HBA for short, regs, basically deal with a workplace where the HBA is deliberately produced, processed, used, handled, stored, or transported in the normal course of business. Now, it's interesting under the HBA regs because they talk to bacteria as an HBA. Examples are bacteria, fungi, and viruses. And the coronavirus is listed there. But you've got to look at what sort of workplaces could one be exposed to this HBA. And here are some useful indicators in Annexure A to those regs. And it talks to the food production plant or a particular workplace where there's contact with animals or products of an animal origin. It talks to healthcare. It talks to post-mortem units, critical veterinary diagnostic laboratories, and sewage purification. That's where you could pick up these HBA agents. So to the extent that these regulations have always had a fairly limited application, that's why the Department of Employment and Labour has asked employers to take account of what's in the HBA regs because they're useful. They talk specifically to your risk assessment, which you will no doubt be aware of how to do those tools, how to exercise those assessments through your health and safety committees, etc. Now, there are also useful guidelines on how to do such a risk assessment, and I just leave that with you. And a lot of you might be saying, well, Fiona, this is all very well, but we're not in an essential service. We're not working at the moment, and we don't know when we're going to get back to work. And when we do, why would this have application? Unfortunately, and as we have seen in mainland China, there's no turn off or turn on of a tap called COVID-19. Even though industry is gearing back to normal and trying to return to normal in that country, there's still infections of COVID-19. So this is going to be with us during a ramp up to production, and we're still going to be making application, I'm sure, or needing to apply these particular guidelines I've been speaking to today. Now, some employers that are in essential services have been criticised, and you will have noticed in the press that the inspectorate, both from the DTI as well as from the Department of Employment and Labour, are out doing particular inspections. They were out 2 days ago in the centre of Pretoria, and what they were picking up are problems. Employers not complying with these HBA regs, in that there was no protective personal equipment available for employees who were fielding questions from the public and looking after the public's needs. This leads to a problem because the department can close you down. There were another example where the employer had provided the PPE to the employees, but they weren't using it, and they stopped the whole operation and said, we can't have this. We are in a crisis situation, and employees, if you don't wear the PPE, you can be disciplined, and that's how serious the department is taking this pandemic, and rightly so. There have also been examples, sadly, of some employers moving beyond what's an essential service and producing in the normal course. And one major international company was stopped. They'd gone beyond what they were entitled to under their permit, and 3 of their managers were arrested and they are still awaiting bail. So the department's taking these aspects seriously, and so should we. I also want to just talk to another issue which has been somewhat contentious, and that's what happens when an employee is at the workplace and has to self-isolate. And is there a need for payment in those circumstances? I read a particular piece from a very different firm of attorneys suggesting this isn't sick leave and the employee is not entitled to any pay. Just to give you an idea how the department is looking at this, and the compensation commissioner, he's insisting that there be payment for that period in his notice. And that's important because one mustn't forget that under COIDA, there is a requirement that the employer should pay for the first 3 months of compensation to an employee that has a claim on the fund, a valid claim on the fund, and is unable to work. Now, that has an implication for us because even though that employee might be dismissed in that time, may not be in the employ of the employer, that 3 month period still has to be paid. It's always been against the opportunity for the employer to recoup that from the fund at the right time. But it's compensation, it's not remuneration. And so the issue is there's a difference between those two amounts. And there's some tension between sick leave benefits in that situation and this compensation that can be claimed on the COIDA fund. I would like to wish all of you great strength in this time. It's not easy. We're seeing some terrible statistics coming through America and the United Kingdom, very badly impacted and becoming the epicenter of this virus. I hope all of us can steer South Africa in the right direction in the hope that we can stave off such huge pandemic and the enormous damage that it can do to our, and will do to our economy. Thank you very much.
Thank you, Fiona. Good afternoon, everyone. I want to speak to 4 things basically. The first is gatherings, specifically in the context of the national state of disaster. Basically what they say we can and can't do in terms of gatherings. Also, I want to look at the international responses to the COVID-19 pandemic, how the lockdown impacts the work of the courts, the CCMA, and by extension, the bargaining councils. And then finally, I just want to touch on picketing in the light of the limitation on gatherings. I want to briefly set out a timeline, and I want you to keep 2 things in mind as I go along. The first is how quickly the virus spreads, and secondly, what I think was a relatively quick reaction to the pandemic in South Africa. So we start on the 31st of December 2019. That's the first report of the virus to the World Health Organization's country office in China. And at that stage, it's simply described as pneumonia unknown cause. On the 9th of January, you've got the first death in China, and that's in Wuhan. And as we know, Wuhan becomes the epicenter of the pandemic, or should I say the first epicenter. Soon after that, China implements lockdowns for Wuhan and large parts of the country. This affects 740 million people. That's almost half of China's population. On the 30th of January, the WHO declares the corona outbreak a public health emergency of international concern. In the first week of February, Jeff Bezos, the richest man in the world, sells $3.4 billion of his Amazon stock. He's not the only billionaire to sell stock for cash in that time. On the 11th of February, the coronavirus is finally given a name by the WHO, and we now know it as COVID-19. On the 5th of March, we've got our first case of COVID-19 in South Africa. That's the man who returns from Italy after spending a holiday there with some friends. By now, we've got 100,000 cases of people infected by the COVID-19 virus worldwide. On the 9th of March, we have the start of the global stock market collapse. On the 13th of March, the epicenter of the virus moves to Europe. On the 15th of March in South Africa, we've now got 61 cases. So that's an increase of 60 cases in 10 days. Internationally, we've got 162,000 cases. On the 15th, the president declares a national state of disaster and he announces measures to fight the spread of the virus in South Africa. On the 18th of March, the regulations in terms of the Disaster Management Act are published. 3 days later, South Africa now has 100 infections. So that's 40 cases in 3 days. On the 21st of March in Africa, Rwanda announces a national lockdown before a single case of COVID-19 had been reported in that country. Now, that's interesting because Rwanda is a country that has a lot of experience already with combating Ebola. On the 22nd of March, India implements its national lockdown. This is a lockdown that affects 1.3 billion people. They received 4 hours notice of the lockdown, which kind of puts South Africa in a very good perspective. On the 23rd of March, the president announces additional measures, including a 21-day national lockdown, set to begin at midnight on the 26th of March. We now know that that was Friday. At this stage, South Africa has 402 cases of infection. That's 302 cases up from 5 days before. On the 25th of March, the amended regulations are published. On this day, we have 330 cases worldwide. South Africa has 709 cases. It's an increase of more than 300 in 2 days. Yesterday, there were 860,071 cases globally. We've had 42,377 deaths and more than 12,000 of those in Italy and 8,000 in Spain. America now has the highest number of infections with over 188,000 cases. And we can see the epicenter is now moving across to the United States. As of yesterday, South Africa had 1,353 cases and 5 deaths. The increase has slowed down. It's a lot less than what was predicted by the Department of Health, and I think to some extent we are showing some flattening of the curve. Today, about a third of the global population is in lockdown. In other countries, governments have also moved to limit the numbers of peoples in gatherings. As an example, Germany, the UK, and now Australia have limited public gatherings to no more than 2 people. In Ireland, it's 4, and in Finland, it's 10. Other countries have also introduced measures. So I'm going to go back to the President's declaration of the national state of disaster on the 15th of March. The regulations that gave effect to that were published 3 days later. These regulations place severe restrictions on a number of constitutional rights, including freedom of movement, freedom of assembly, and obviously the freedom to trade. The President introduced 3 broad measures to fight the spread of the virus. Firstly, he looked to limit contact between South African citizens and foreign nationals who may be infected. This included restrictions on visas for foreign nationals, stopping flights, closing airports and harbors. Secondly, and this is the more important one for my part of this presentation, he sought to minimize the spread of the virus by limiting contact amongst groups of people in South Africa, i.e. amongst citizens. And thirdly, he's looked to strengthen surveillance and testing of COVID-19, and we can see we're now finally moving into this phase. Coming to the limiting of contact amongst groups of people, the regs introduced on the 18th of March go to some extent to addressing this issue. The regs produce some interesting definitions. So the first one is adequate space. And in terms of the regs, adequate space is not more than 1 person per square meter of floor space. It also introduced a definition of gatherings. So in terms of the initial regs, the gatherings were defined as any assembly, concourse or procession of more than 100 persons, wholly or partially in the open air or in a building or premises. There is an existing definition for a gathering in terms of the Regulation of Gatherings Act, which is a very different kind of definition. So in terms of that act, a gathering is any assembly, concourse or procession of more than 15 persons in or on any public road or any other public space or premises, wholly or partly open to the air, at which policies, actions, etc. of a government or political party or an organization are discussed or attacked, or where it's held to form pressure groups to hand over petitions to any person or to mobilize or demonstrate support. So you can see the definition in the Gatherings Act is basically limited to your protest action type of event, whether it's against the government or political party or even an employer. In that definition, you'll see it's also in a place or premises that's wholly or partially in the open air, so not in a closed building. The definition that was introduced in the regs on the 18th of March is extremely wide. So all you basically need is 100 people anywhere and for any purpose, and you've got a gathering. That's restricted in terms of those regs. So this raises obvious problems like how do you run a hospital when you have more than 100 people assembled in a building? Or how does a prison run? How do factories and distribution centers that are critical to the supply line for essential services run with less than 100 people? It's impossible. So obviously there are some problems with that initial definition. You'll see later that the definition has been amended in the subsequent regulation. I just want to look at some of the regulations in the 18 March regs, which are pertinent to gatherings. Regulation 3 deals with the prevention and prohibition of gatherings, and gatherings in terms of that regulation are prohibited to contain the spread of the COVID-19 virus. An enforcement officer where a gathering takes place must order the persons to disperse immediately, and if they don't, the enforcement officer must take appropriate action, and that can include arrest and detention. We've seen that there have been more than 2,000 arrests nationally, so it just shows you how seriously the police are taking the enforcement of the regulations. So that's 2,000 people in 5 days of the regs being enforced. The regs also introduced an assembly of no more than 50 persons, sorry, a prohibition rather, on an assembly of no more than 50 persons at a premises where liquor is sold and consumed. Regulation 11 deals with offences and penalties for breaches of the regulation we've just looked at now. And what's interesting about Regulation 11 is that it targets the person who convenes the gathering. And the penalty there is that somebody who's guilty of an offence is liable to a fine or imprisonment for 6 months or both. On 23 March, the President made another statement and introduced us to the government's attempts to escalate the measures to combat COVID-19. Some of the more significant aspects of that speech were the introduction of the 21-day lockdown, starting on Thursday the 26th of March and ending on Thursday the 16th of April 2020 at midnight, i.e. on the Friday. In terms of his speech, all South Africans must stay at home except where they're exempted, and the exempted categories of persons who can leave their homes are broadly workers in the essential services, and that includes health workers, emergency personnel, security services, those workers involved in the production and supply of food, and power, water, sanitation, and telecoms workers. For the rest of us, we can't leave home except under strict conditions, and those are to get medical care, to buy food, medicine or supplies, or to collect our social grants. All shops are closed except for essential services. Retail stores which provide essential services can only sell essential goods. The The amendments to the regs to give effect to that second speech were published on the 25th of March. For our purposes, the most important aspect of that is the change to the definition of gatherings. So there's a new definition now, and that's any assembly, concourse or procession in or on any public road, or the second part's the important one, any other building, place or premises, including wholly or partly in the open air, and including and not limited to any premises or place used for sporting, entertainment, funeral, recreation, religious or cultural purposes. So you'll see from that second part of the definition, it's cultural, sporting, entertainment, religious kind of events that they've referred to. There's no mention in there of a workplace. And if you recall earlier, I raised concerns about hospitals and DCs and factories and prisons who can't operate with only 100 employees. So in my view, you have to read the definition as limiting gatherings to those kinds of situations that fall into that broad category of cultural, religious, sporting, entertainment, etc. type events. The department, however, has issued certain contravention notices to a number of retail stores, insisting that there be no more than 100 people in the store, that staff and customers. I'm not sure if that is correct by the department. The regs also define what a lockdown is, and basically that's the restriction of movement of persons for the period of the regulations. Movement is also defined. This means entering or leaving a place of residence. So you can see the intention in the regs is that during the period of your lockdown, you must be in your home, in your residence. I want to look just briefly at the restrictions on the movement of persons and goods that were introduced in the second regulation. So some of the more important ones are that every gathering is prohibited, except for a funeral where attendance is limited to 50 people. Movement between provinces is prohibited. So we've just received a judgment, an ex parte application by Van Heerden. Van Heerden resides in Mpumalanga, and on the 27th of March, so that's the day of the lockdown, he received a call from his mother. She told him that his grandfather had passed away. He died in a fire at his home earlier that morning. His father lived in the Eastern Cape. Van Heerden obviously wanted to support his mother and wanted to be in the Eastern Cape to be with his grandfather, to help with the grandfather's funeral arrangements. But obviously in terms of the regs, he's prohibited from traveling to Mpumalanga from the Eastern Cape. And being a good citizen and not wanting to break the law, he approached the court on an urgent basis, seeking an order to temporarily be exempted from the traveling restrictions. So he argued before court that that there was no risk of him contaminating anyone. He hadn't been in contact with anyone from abroad. He also hadn't been in contact with anyone who had the virus, and he didn't display any symptoms. He also undertook to comply with all the provisions of the regs and to use all necessary precautions to prevent contamination or spread of the virus. The judge was sympathetic to his personal circumstances, but the judge refused to grant him the order and dismissed his application. And it shows you what a hard line the courts are likely to take in enforcing the regulations. Just going back to the regs, movements between the metropole and the district is also prohibited. All businesses must cease operations, except for those involved in manufacturing, supplying, or providing an essential service or good. Retail shops and malls must close, except where essential goods are sold, and on condition that the stores put in place controls that ensure customers keep the appropriate social distancing distances between them. So that's at least, sorry guys, I seem to have lost my connection. Am I on? Sorry about that. I lost you off the screen. And So I was saying that retail stores and malls must close except where they're doing essential services, and customers, they must ensure that customers keep a distance of at least 1 square meter apart. They also have to observe all hygiene conditions to prevent exposure of persons to COVID-19. I said already, retail stores selling essential goods are prohibited from selling any other goods. The controversial item here, obviously, as you know, is the ban on cigarettes, and it seems like that may be relooked. Any buildings where non-essential services are conducted are closed, except for security staff and maintenance staff to protect the building and keep it going. All borders to South Africa are closed except for the transport of fuel and essential goods. If we look at Regulation 11C, that basically prohibits the operation of any public transportation. So that includes rail, bus, taxi, e-hailing services, maritime and air passenger transport, except for the purposes of transporting essential service workers, or to allow people to obtain essential goods, seek medical attention, or attend funeral services, and to collect their grants. Where a person rendering an essential service is unable to travel to and from work, the employer must make the necessary arrangements for that employee. There are restrictions on the capacity of vehicles that are used for transporting these employees. In terms of the regs, not more than 50% of the capacity of the vehicle can be exceeded. I know that the Minister in Communications has now increased that to allowing 60% of the vehicle to be used. And then also all the hygiene and other limitation protocols have to be observed in transporting that person. Next, I want to look at just how the Labour Court and the CCMA are dealing with the lockdown. The Labour Court's issued a number of directives. The final effect of those is that all matters allocated during the period of the lockdown have been removed from the roll, so they're not going ahead. There are no judges at court. The registrars, etc., may be there as their essential services employees. If a matter is urgent, the parties are to approach the registrar, who will then approach the duty judge, and the duty judge will then decide if the matter is urgent, and if it is, the application will be dealt with telephonically. The Van Heerden matter that I referred to earlier, that was in fact dealt with telephonically. No parties appeared before the judge. This does raise some interesting questions. If you can't commission an affidavit, because most of these applications, well, all of the applications are done in affidavit, what is the status of that document? Do you have to have the deponent present on the line before the judge to verify their identity and confirm the veracity and the truthfulness? So we're going to have to deal with this very practically and very differently to the way we as practitioners are used to dealing with these matters. In terms of the CCMA, they've suspended all their services except for the terse applications, and they'll only accept emailed or fax referrals now, but nothing's going to be set down. Lastly, I want to look at picketing in light of the restrictions on gatherings placed by the regulations. So we all know the process that leads us up to a picket. There's got to be a dispute. The dispute has to be referred to the Bargaining Council or the CCMA. And if it's not resolved, then the parties have to agree picketing rules, or those have to be established by the CCMA or the Bargaining Council. And only then can the union issue a strike notice. After that, they can then conduct the picket. In the lockdown, employees will not be able to picket. So the CCMA and bargaining councils won't accept referrals. Accordingly, picketing rules can't be established. So unions simply won't get past go during the lockout. We don't know what will happen after the 16th of April. The lockdown could be extended, or we could revert to a situation where the regs of the 18th of March are enforced, so the pre-lockdown regs. There'll still be restrictions on gatherings. We also have to see what the CCMA does. Are they going to be open for business? Are they going to accept these kinds of referrals? If they are, then it's conceivable in that pre-lockdown reg kind of scenario that mutual interest disputes will be conciliated. If they're not resolved, that picketing rules can be established. These picketing rules, however, are going to be fundamentally different to what we're used to. So the rules in that period would have to include social distancing. They'd have to take account of the hygiene protocols and measures to avoid the spread of COVID-19. There'd be a limitation of 100 people to a picket. The adequate spacing provisions would be policed. Because the picket's now covered by the regs as well, you now have a situation where law enforcement will police and intervene and make arrests in the picket if necessary for non-compliance with the regulations. So what we've also seen is that if there is non-compliance, law enforcement can now go after the conveners of the picket, and the conveners could face up to 6 months imprisonment or a fine or both for not having the picket comply with the regs. Interestingly, we have had some industrial action just before the lockdown at the Pick n Pay Longmeadow Distribution Centre just before the lockdown. You'll appreciate Pick n Pay is obviously a national retailer. It's an essential service, and the DCs are a critical part of the supply chain. The employees at the DC decided to go on unprotected strike action. There was some dispute about health and safety and an incentive payment. The employer issued ultimatums to the employees. They refused to honor those or to observe them. The CCMA was called in on the 26th, so this is the Thursday before the lockdown, to intervene. The union became involved. The union and Pick n Pay then reached an in-principle agreement on the incentive, and also that no disciplinary action would be taken against the workers that went on strike. The union took that to the workers. They, however, rejected the proposal, and in pretty much unprecedented territory, you had the minister and the CCMA addressing the workers and emphasizing that they go back to work in the national interest. They did eventually go back to work, and the minister subsequently appealed to all workers across all essential services to refrain from any unprotected industrial action during the lockout. Thank you. On that somber note, I'm going to hand you over to Hugo Pinar.
Thank you, Jose.
Thank you, Jose.
It's a backslash on mine. Let me just, I think I must just, there's a backlash on mine. Okay, it's fixed. Thank you. Thank you. As Jose indicated, it's such a gloomy topic, and we know that people are being locked down in their homes, etc., and that puts pressure on family life. So we thought that we will introduce some good news also on a lighter note. And the first one is we've decided to now launch a family law department, and in order to celebrate that launch, we will, on the 10th day of the lockout, have all divorces on a special. So that's the first one. The alternative to that, if that doesn't work for you, is we're currently investigating the possibility of having funeral policies at a reduced price. Now, if that doesn't work, we don't have any advice. So let me talk about the duty to pay. The duty to pay employees during the period of the lockdown. Now, I'm not talking about the status of sick leave. We know that when we deal with sick leave, that's all contained in our survival guide, and you can visit that, and that gives you all the answers. I'm also not talking about people who are currently working from home and to receive their remuneration. We also know, and that's a third category that I won't be talking about, would be where you have employers paying employees their salary because they've made some arrangement or undertaking given to our president. We know that before he announced the lockout, that he had several discussions with large businesses and secured some undertakings. So I'm not talking about those categories of people. I'm talking about companies affected by the lockdown where my business is closed. I can't operate. I've been stopped from operating. The employees can't tender their services. They've been because of the lockdown, and the company can in any event not accept any tender of service, and consequent to that can't pay the employees. Now, if we go back, or can't pay the employees in many instances. Now, if we go back to the principles or the basics of a contract of employment, we know that in terms of a contract, the employee must work for the employer, and in return, the employer will pay that employee. Now, in the current situation, the employee can't work, and the issue of pay is the question that we need to address. But the point is, in many instances, because companies are marginal, they can't afford to pay employees' salaries since they have no income. And whether we call it force majeure, supervening impossibility, doesn't matter. The bottom line is the law is clear, we think, on that there is no duty to pay under the current circumstances. And we've seen that there are comments from the minister and otherwise that the companies are now shifting the burden to employees of applying or forcing employees, force quote unquote, to take their leave and to take unpaid leave, and I intend to address that now. So starting point, no duty to pay. Second one is the issue of leave, and it's important that you draw a distinction between statutory leave, that is the minimum leave prescribed in terms of the relevant legislation, and two, contractual leave. Contractual leave would be leave paid in addition or provided in addition to the minimum statutory leave. Now let's talk about statutory leave first. Now in terms of statutory leave, the law is clear on that too, and there's a section 20 sub 10 sub B which says that the employer can determine the time that the employee takes the leave. So that's up to the employer to decide. Statutory leave, you must take it now during the period of the lockdown. I do not need your permission to do so, it's actually contrary to the perception that that's an abuse by employers. The employee has accrued the annual leave, and I'm putting the employee in a better position now where the employee will, at least as long as the leave is available, get paid. That's better than having to rely on any of the other funds that might be at the disposal of the employee, where the employee would receive much less. There are employers, as we know, that says that I can't even do that. I can't even pay you in lieu of your leave during this lockdown period. And of course, there the employees go straight into one of the funds to submit their claims. On contractual leave, it's different. There we need the consent of the employee to actually pay the employee the outstanding leave during the lockdown period. And if the employee refuses to consent to that, what you will do as an employer to then proceed with an unpaid leave scenario. In other words, the employee would go home and not receive any leave pay, any contractual leave pay. The interesting question that now, of course, arises is that what about future leave? Some employers say, well, we estimate that for the remainder of the year, you'll accrue a further 6 or 7 days leave, can I use that, or can I implement that unilaterally? And then, of course, the question arises whether that forms part of statutory leave, or does that now constitute a form of contractual leave? And you know, these are the type of questions that will arise, and we would invite you to liaise with the relevant person at the firm that you deal with in order to assist you in this regard. But there is that big debate going about future leave. Of course, there is then the issue of questions being raised or proposals being made by other people that says, well, why you can utilize also your family responsibility leave. Of course, that is utter nonsense. And for the same token, you would not be able to take your sick leave and be paid out for that now, unless of course you're sick, and you would equally not be paid out for maternity leave unless, whether I say maternity leave, whether it's work-related incident or not, you will not be paid for that either unless there's a provision for maternity leave in your paid maternity leave in your contract of employment. So let's just look at some of the provisions that may be available for employees to claim or for employers on their behalf to claim. And we've seen the minister's comment that it's ideal for employers to rather put in those claims where appropriate on behalf of the employees. Now, there are different funds that you'll recall that Mr. Ramaphosa spoke about. The first is the so-called Solidarity Fund. That's where major R1 billion contributions were made by big business people in our country, and we salute them for that. And you'll see the purpose of that is not necessarily, and I say not necessarily because we don't know yet whether those monies could be filtered through to some sort of disaster fund or not. It's not impossible if you look at the wording of Mr. Ramaphosa. We know that there are then the so-called TERS, the Temporary Employee Relief Scheme. There's a so-called National Disaster Fund. We're not sure if that is currently, will that form part of TERS or not. And then there's the normal UIF benefits where people can claim for reduced working time. And what we would propose again, when you submit those, that you talk and discuss this and get advice from your contact person at CDH, because it obviously has its intricacies and there are consequences to that. And in particular, when you look at the temporary relief scheme, it must show that the company is in distress, and that may have commercial consequences for the company at a later stage. So one is cautioned as to when you apply for it and how you apply for it. But the idea is ultimately that companies would put in the claim and would then refund the employees. We also know that there are collective agreements. There's one in the textile industry catering for forms of pay, and my understanding is currently in the MEIBC, they're busy negotiating an agreement on that. Gordon, you can maybe highlight that specific issue. So that brings us to the further questions. And can I just maybe summarize? First, no duty to pay. Two, if you want to utilize leave pay, you may use so unilaterally. When you talk about statutory leave, contractual leave, you need the consent. Once all of that has been exhausted, there are other funds that you can look at support. And remember, when you talk about the different funds, you can't double dip. The question, of course, arises, what will happen in a few weeks' time at the end of the lockout? What will our president do? Will it be extended? And we don't know. Or we know that he'll probably have a choice between stopping deaths or stopping employment. And I think the answer to that is self-explanatory. The question that you need to think about at the end of the lockdown, you may not be able to continue with the business on a 100% capacity basis. And then you may consider, but maybe I only need half of my employees, or if I utilize the services of all my employees, what will I do with regard to reduced hours or reduced pay? and my sense is that we will talk about that in time to come. Also, after the lockdown, we know that there will be a bloodbath of job losses, and you won't have commissioners to facilitate if these are large-scale retrenchments. Those are matters that we will address in time and that you need to think about. You need to think about the consequences of the fourth industrial revolution now being brought forward. Interesting that I've learned this morning that Ford manufacturers together with 3M are now building ventilators, and they're using some sort of part of the current Ford machinery to do that. I hope it doesn't become a burning issue like the Ford Cougar at the time, but time will tell. But the point is the Industrial Revolution has taught us, and which is brought forward, how easy it is to, relatively easy it is to communicate and work from home and all of that. You may consider after the lockdown that you will have union rivalry. They will look for a scapegoat. Employers are in all likelihood as the enemy will become one. You'll have a different type of dialogue. You'll have a different type of social accord and all of that. And all of that one needs to consider and which we will potentially address later. Be that as it may, we know that we'll have to work smarter and revisit our traditional weapons. And if I say weapons, I refer to value and weapons, because we can't go back to the old school as we've had it. We know that it's a time of change. Lovemore Mbeki wrote about change when he wrote the book Ubuntu, and he says, manage it rationally or let it happen chaotically. But all of this is about legislation and how we're going to adapt to that or to adapt to that. And Harry Oppenheimer at the time said, it's not enough to change legislation. We need to change the hearts of our people. And I'm sure that's where we are. Thank you, Adel. Over to you.
The next part of our session is to go through a host of questions that participants have been so kind as to place on our webinar, as well as send it to the email address which popped up. The structure of this is that I'm going to take groups of questions, and before I end, Gordon will answer or will address some of the issues peculiar to the industry and make some general concluding remarks about what is envisaged going forward. The first group of questions, and understandably so, and these are for Fiona, relate to COIDA and the Occupational Health and Safety Act. And so the first thing is, what are the requirements of PPE pertaining to COVID-19? And thereafter, what documentation must you provide to qualify for the 14 days sick leave in relation to that? And the last one is a philosophical question, if I may say, that the Act requires, or the regulations require, employers to make payment and then claim from COIDA, or the Compensation Commission, and what guarantees, if any, does an employer have in this regard? Fiona?
Thank you very much. The first question with regard to what would be relevant personal protective equipment is largely going to be dictated by the type of workplace that you have and the work that is being undertaken. Generically, one is reading a lot about the use made of masks, overalls, and gloves. Now, what is quite important in this regard is that the Compensation Commissioner is hosting weekly sessions with business leaders and healthcare associations to discuss what is relevant in this situation, and more importantly, how to use PPE. We're expecting out of that session to receive protocols which are going to be developed on how you use hand sanitizers, how you use masks and gloves. There's extremely good reason for this, because one may have good intentions by providing masks, but what they're finding is that employees are not necessarily used to wearing masks in every instance, so they fiddle with them, which means the hands going to the face, the very thing you want to avoid for the transmission of this particular illness. We're also expecting to hear training on the use of these PPE, but you can accept generically that you're not going to get away with much less than masks, and certainly gloves, and definitely sanitizers. You're going to say to me, Fiona, there's a massive shortage of these masks. I can attest to that, because a friend of mine and myself actually made 80 this weekend for staff at Baragwanath and Union hospitals. Why? Because we just don't have enough available. In surgical wards, they've been issuing one mask to a doctor to be used for 1 week. It's not acceptable. But there's a mass shipment, or it might even be coming in on air freight from China, some 3 million masks that are going to be made available. So South Africa, the government is definitely taking this very seriously, and at this meeting that went ahead this morning, this issue of shortages of PPE was raised. So that's what I want to talk about in relation to the first question. Always remember, it's your risk assessment too that's going to assist you to identify what would be the appropriate PPE to use in this situation. What documents should be provided in order for a person to qualify for 14 days of sick leave should they have to go into quarantine? The notice from the Compensation Commissioner that I've been talking about this morning talks directly to this issue, namely that there needs to be a medical certificate, at least a sign-off by a doctor that it is imperative that this person go into quarantine. That's where the payment will come back to the employer to apply the provisions of its sick leave, either in terms of policy or in your particular instance, also your main agreement. Now, the philosophical question with regard to whether an employer can, in all fairness and honesty, believe that it's going to be reimbursed if it pays out on those 3 months that are required to be paid as compensation whilst the claim is being managed by the Compensation Commissioner. Firstly, it's been my experience, but admittedly this has been with Rand Mutual, that's an accredited agent sitting alongside the UIF agency. It's accredited under COIDA and it operates in the mining sector. The reimbursement took no less than 5 days, so it was quick. I have great faith that our Department of Employment and Labour fully appreciates that there's strain both sides, not just for employees only, but employers. And I believe certainly with regard to the compensation fund, that money will be dispersed as soon as possible, given the circumstances. It will also be dependent on exactly how many claims are lodged, and more importantly, whether those claims are accepted or not. Thank you.
Good. Thank you, Fiona. The next batch of questions, and understandably so, relates to the various relief that an employer who does not pay its employees and is able to claim from the UIF. There's been conflicting information that's come out of the department and of the regulations and of the easy guide. As of today, 1 April 2020 at 14:10, Hugo will tell you what the law is. Please note that this may change later today, as there have been on a continuous basis. Just hot off the press, we've been informed that they, as indicated initially, that the temporary employment relief scheme, there should be more rules to be published later this week, which will hopefully clear up the guidelines or the requirements in relation to it. But as it stands as of today at 1400 hours, Hugo will tell you what the provisions are as such.
Arnold, it's 14:10, so you might have read something different in between, but the bottom line, as Arnold suggested at the start of this discussion, is that the regulations have changed and the comments have changed from time to time, and the sentiments will continue to change from time to time, which means that whatever is the position now may be different later today or even tomorrow. So that's the first point of departure. The second thing is that some of those questions are more complicated than others, and it's easier to just liaise again with the relevant person at CDH to guide you. But certainly the first one is you would have, ordinarily you would have your normal UIF benefits. That is where people work reduced time and you put in that claim. This is not a TERS claim, and that is your section 12(1)(b) claim, which you will submit. And my understanding is that there's a request that employers now submit that in order to ease the burden on the fund and in order to address queries. The second main thrust of claims you will find under the TERS, the Temporary Employment Relief Scheme, and our understanding, and again look at our survival guide, is that those are for companies under distress and they have not worked during this period of time, and then the employer can submit that claim, and there's a whole bunch of questions and requirements that must be met. There is a third fund, and that is the one that there is uncertainty about, and that's the National Disaster Fund, and it's uncertain whether that now will form part of TERS or not. We will hopefully have more detail on that later, except at this stage all we know is that they talk about that 3,500 Rand flat rate. So those are more or less the three options available for employees, and of course for employees to submit on behalf of the employees. And as I've indicated, there are also, as I would suspect in your industry now, that some of those claims would be in terms of an agreement go via the relevant bargaining council. Thank you.
Sorry, I apologize. I was on mute there. I apologize for that. The next set of questions is the registration on the portal for the Department of Trade and Industry. What are the requirements? What happens if you do not fall within a subcategory? And can the department retract any certificate that was issued or that you applied for on the portal? And in that regard, I'll give that to Jose. Thank you.
Hi, Odile. It's a little bit left field for me. Not really my area of speciality, but I do know that the department have what's the word I'm looking for? They have looked into registration, and those people that they've found have registered fraudulently. They've withdrawn their right to operate as an essential service, and they'll be prosecuting them criminally. I'm not too sure about the practicalities and how you would actually apply, but that's about as far as I can take it.
Good. The thing is that the registration of the Essential Services Portal is not a legal requirement, it's an administrative requirement. The mere fact that you get a certificate does not mean that you're an essential service provider. If you falsely declare, in those circumstances, they will come against you criminally. If you don't fall within a subcategory, that means simply that they don't regard your business as essential. They want to shift the burden or the obligation on you to be truthful. This is not about the law. This is more about self-regulation. So you regulate yourself. You determine whether you are essential, and when called upon to justify whether you're essential or not, if they find that you are not essential, then in those circumstances, you are criminally liable. There's another thing which, for Fiona, just to talk a bit about sick leave and what happens. So when can you claim sick leave, and under what circumstances are you entitled to additional sick leave if your allocated sick leave has been exhausted?
Okay. So in answer to that particular question, one must remember that sick leave is not an entitlement. It's something there that an employee can use if they're genuinely medically incapacitated. So it's not a situation where I can approach my employer and say, I've exhausted leave that I've chosen to take because the lockout has been extended and my generosity of my employer has got its limitations, and therefore I do have sick leave. I'm a person who's never been ill for the last 2 or 3 sick leave cycles. Grant me what I'm entitled to under the main agreement. My answer to that is no. Unless this person is genuinely ill, the sick leave cannot be applied in that manner. It's inappropriate. Again, I stress, it's not an entitlement.
Good. Thank you, Fiona. The next set of questions, and maybe this is something that I could just answer. There seems to be a host of questions that have come about regarding TERS, the national disaster. When can you claim? Can you claim under TERS and still pay your employees? The answer is 1, the Unemployment Insurance Fund. 2, TERS is only available to people who do not get paid. You cannot, under the UIF regulations, claim under TERS and claim under another benefit. Now, what do employers do at this stage, given the uncertainty regarding TERS? Please wait. Clarity will be forthcoming in the next couple of days, and it is not there's no sort of prescription period at this stage. Apart from the UIF, the the Treasury and SARS have issued out various funds that are available to small and medium enterprises. That's beyond the scope of this session, but it's something that you may want to look into, or with your accountant or your tax lawyers, in order to get further advice as to how you can deal with it. The sort of last question before I hand over to Gordon is to Jose, regarding the question says that where my payroll is an essential part and I need to travel from Pretoria to the East Rand in order to put my IT system on, or I want to ensure that my payroll runs, would I be fined, or what do I need to do in order to undertake that sort of work?
Thanks, Adil.
Sorry, I think Jose's mic is switched off, so he'll be switching it on in a moment. Thank you.
Hi, guys. There is a permit which is issued in terms of the regulations. It's a relatively simple form which the employer has to fill in and has to stamp with an official stamp. And that'll record your identity, the identity of the employer, the reason why you need to be at work. And if you are stopped, you can produce the document and show it to the law enforcement official. If that part of your business is an essential service, then obviously you're entitled to travel. I'm not sure if there's anything I'm leaving out. Have I answered the question, Adil?
Sorry, you've answered the question succinctly and clearly. Thank you. There are a host of questions for Gordon, which I am going to hand over to. And if please keep your questions coming, so before we close off, we can then answer those remaining questions. Thank you. Gordon, over to you.
Thanks very much, Adil. I hope I've got all of the questions that were asked of me, but obviously, as Adil has said, if there are more, please keep them coming. The first one that I would like to deal with is around the main agreement and the leave provisions contained in the main agreement. Particularly, the question that was posed was, does that leave constitute statutory leave or contractual leave? Look, a couple of preliminary comments here, and it's a peculiarity really in the metal industry at the moment, in that there is no binding extended collective agreement in place. Following the 2017 main agreement negotiations, there was a group of employers who reached an agreement with the trade unions of the industry. And upon reaching that agreement, then refused to engage with the rest of the employers of the industry, and decided instead to try and extend their agreement on the rest, which has to date proved unsuccessful. So in that context, I think that it's important just to realize that there's no binding collective agreements in place. Be that as it may, the main agreement that we are familiar with and have been bound by in the past makes provision for 3 weeks annual leave for all employees who have up to 4 years service, and then upon completion of their 4th annual leave cycle, so in other words, completing their 4th year of service, become entitled to a 5th week of annual leave. Now, the agreement also deals with annual shutdowns, typically taken by companies, majority of companies in the metal industry over the December period. Now, the way that the agreement works is that for companies that are observing a shutdown, that shutdown needs to be long enough for the employees to take at least the 3 weeks of their annual leave, whether that's all of the leave available to that employee, or for the longer serving employees, 3 of their 4 weeks. The remaining week, there's various options that can be utilized in terms of the main agreement, which is that that additional week can be taken at the time of the annual shutdown. It can be taken at some point after the annual shutdown, the first 6 months of the following year, or employees can be paid out in lieu of taking that leave. So I think that for clarity, and I'm subject to being corrected by my learned colleagues on the panel, but the leave under the main agreement would be considered to be statutory. In the absence of a binding collective agreement, I think the legal position is that the Basic Conditions of Employment Act would apply insofar as enforceability is concerned. And comments have been made by Hugo in that regard about that being statutory leave. So I think that that the leave under the main agreement would be considered to be statutory for this purpose as well. The next question is a little bit beyond my scope because it's relating to farm workers, and the question that's been posed is that farm workers are considered essential. If they then don't go to work, would it be unpaid? I think in that regard, we'd be guided by what Hugo's said earlier on, in that there's no duty to pay. So there, the principle of no work, no pay would apply. And how you would then engage with those employees if they should be at work and are not, in the circumstances, from my perspective, would be a case of trying to talk to them, explain the situation, ensure that they have a proper understanding of what it is that they're meant to be doing, that they are in fact considered to be essential, and try and get them back to work that way and deal with it. The third question that has been posed is a company which may have perhaps a shorter shutdown over the December period and is contemplating perhaps shortening, if I understand the question correctly, their December shutdown period in light of what's happened now. Could they have their employees take annual leave now, perhaps 2 weeks annual leave, and then have a shortened annual shutdown in December? I think the answer to that is yes, absolutely. There's no reason why, certainly by agreement with your staff, you can have your employees put in annual leave now. As was mentioned by Hugo earlier on, it's much better situation for employees to receive full payments over this period, if at all possible, even if that means perhaps working a little bit longer into December or coming back a little bit earlier in January, and being compensated for this for both sets of leave, so to speak, in the long run. I think that would be preferable to all parties. Then there is another question which is relating to the various funds. And the question is, are the various funds only available for SMMEs? I think that the distinction that has been made during the course of the webinar is that the TERS arrangement is specifically designed for compensating employees who are not being paid during this compulsory lockdown period. So that's for employees who are not able to work due to being subjected to the lockdown rules and regulations, and the employer is not paying them for that period, and therefore will put in a claim with the UIF through the TERS system, the Temporary Employee Relief Scheme system, to be able to pay out those employees or remunerate those employees. So that's a separate issue, and that's not restricted, as far as I'm aware, to small to medium-sized enterprises. What is, as far as I know, applicable to small and medium-sized enterprises is the funding that's available through the Department of Small Business Development. That, from what I can see, has been earmarked to be used exclusively by companies, or made available to companies who have an annual turnover of less than 50 million rand. So that funding, I think, would be earmarked for SMMEs, and then comments have been made around the other funding, such as that which is dealt with through the Solidarity Fund. I think the clarity that is needed will be forthcoming in the days and weeks to come on that. And then I had one final question, if I may, that has been posed, that where somebody has asked that if they have been retrenched, being given 1 month's notice with their notice period ending at the end of April, the question is it allowed, and can a claim be put in from TERS and the UIF? I think in that scenario, the answer is as to whether that's allowed. The question would have to be asked, well, so long as a proper process has been followed in terms of Section 189 or Section 189A of the Labour Relations Act, there's nothing to say that the retrenchment that might have taken place wouldn't be allowed. Insofar as the claim from TERS and the UIF is concerned, it would be the ordinary. The claim from the TERS wouldn't be allowed, because the TERS claim would be payable to employees who remain in the employ of the company. Obviously, in a situation where an employee has been retrenched, that the contract of employment has been terminated between the employer and the employee, and there'd be no access, as far as I'm aware, to the TERS funding arrangements, but an ordinary claim, for want of a better expression, perhaps from the UIF, would be the avenue to pursue for that person.
Thanks.
Thanks very much, Adil. Over to you.
Gordon, I think that there's just a particular question regarding how does the lockdown affect from the collective agreement if you're able to shift work in the calculation of bonuses and leave bonuses? If you just want to address that by. I'm not sure. I think that's just sort of a general question.
No, that's fine. I can definitely address that. Look, the fact of the matter is that the arrangements in the industry, including the main agreement, obviously in the context of what I have mentioned, insofar as there being no extended collective agreements in place currently, be that as it may, the main agreement doesn't make provision for the accumulation of shifts in this particular instance. In fact, the main agreement is quite specific insofar as when employees are able to accumulate shifts, and it certainly does not provide for a situation like this. So my view would be that under the main agreement, the employees would not accumulate shifts for the purposes of leave pay and leave enhancement pay. I hope that answers the question sufficiently, Adil.
Thank you. The next, I think there's just 3 more questions. The third last question is, if your employee, and Fiona, this is for you, if your employee arrives ill at work, what are your obligations in relation to that employee insofar as taking that employee to hospital, ensuring that the employee goes home, and the like, if that person contracts or that person is affected by the COVID-19?
It's a very good question. I'm glad it's been posed. The employer has a duty of care. That's in the common law. It's recognised as well under the OSH Act. What I would propose in that situation is the employee is withdrawn from the workplace immediately. But not just a question of perhaps being sent home, if there's definitely a sign that there are symptoms that could be attributable to COVID. For example, suddenly running a fever, and certainly the onset of a cough, a persistent cough. In that situation, one would immediately want to ensure that person gains medical treatment at the facilities demarcated to deal with these COVID virus cases. Charlotte Makeke is one that comes to mind, but I know that the government is looking to open up even private sector hospitals to cope with patients, but those would be patients who are requiring intubation and who are at an advanced stage of this particular disease. One has been asked by the South African Medical Association, a client of ours, funnily enough, not to go and send persons to the local general practitioner, for the reason that if the person is contagious, then it's just going to impact on others who may be validly attending those surgeries for different and equally problematic, perhaps, ailments and need attention. But to rather go to the facilities demarcated for this, the Department of Health has it on their website as well. So that would be my advice. But from the perspective of your own workplace protocols, if one is an essential service or becomes an essential service, it's important that there is a policy where you withdraw if the person is exhibiting signs. And you might say, Fiona, what do you mean by future essential services? Certainly Hugo touched on it. I'm seeing this more and more, that companies are going to be approached for the purposes of producing equipment that's necessary in hospitals. Certainly, I think South Africa might even be called upon to start making its own respirators, and perhaps in your sector, companies will be approached to make the stand units and issues like that, or aspects like that, to assist government with this crisis. Thank you.
Thank you. Can I then, just before I conclude, there's a host of questions regarding, and I call them administrative questions, in the sense that it is not being able to contact the UIF, not being able to download the forms correctly, not being able to log on to the website, waiting for the forms. The only sort of advice we're giving to clients is persistence. In those circumstances, the Department of Employment and Labour is inundated with issues, and I understand that people cannot physically go there. There does seem to be a lag, but a lot of our clients have indicated that they've received quite good responses and a fair amount of feedback. The administrative issues, which are the sort of non-legal issues, you may want to continue persisting and achieve some success. If all of that fails, you may wish to just contact your representative or Gordon, who will be able to assist you or to try and facilitate those sort of administrative issues. We have now come to the end of our session. If we have not answered all your questions, please feel free to send it to your respective representative at our firm, alternatively to Gordon, and he will unsend it to Fiona or anyone else to answer, or give you the necessary contact details. We thank you for attending our webinar, and hopefully this is a partnership that we build on and grows from strength to strength, so that we can meaningfully contribute to the economy and to your business and to your sector, and become true partners to you, as and Fiona is the key representative. She and Gordon are here and will call on any of us should any assistance be required. Hopefully, the fourth industrial revolution, as Hugo has indicated, has arrived on our doorsteps, and we hope this has been a rewarding, empowering, and knowledge-filled experience. Thank you all.